A warning now coming out of the Texas pistol brace case is sharpening a question a lot of people thought was already settled. The federal brace rule is still gone. That has not changed. But the Department of Justice has now made clear in court that even without that rule, it still believes some brace-equipped pistols can be regulated as short-barreled rifles under existing federal law. And that is why this story is moving again. If you watched my earlier Thomas Updates video on the Texas brace case, then you already know the full background on the March 16 filing itself, so I'm not going to spend this video redoing that whole timeline. What's new now is the reaction to that filing and why it matters. One of the plaintiff side groups has now gone public with a warning to gun owners after the government's position was spelled out in black and white, and that shifts this from a technical court argument into a much more practical question. What exactly is still being enforced and against whom? Here is the clean version. In State of Texas versus ATF, the DOJ filed a reply on March 16th asking the federal court in the Southern District of Texas to dismiss the case as moot. The government's argument is that the 2023 stabilizing brace rule has already been wiped out in separate litigation, so there is no longer a live APA challenge to resolve here. But inside that same filing, the government also said ATF still enforces the NFA and GCA rules on short-barreled rifles against some brace-equipped pistols, even though the rule itself has been universally vacated. That is the part people need to separate carefully from the headlines. There has not been a new court ruling saying the brace rule is back. There has not been a new nationwide ban. There has not been a new published rule from ATF reclassifying every braced pistol. What exists right now is a government filing saying the agency still believes it can apply the underlying statutes in at least some cases without relying on the old rule. And that is exactly why this has become the live issue. The old fight was over the formal rule. The new fight is whether the same result can still be pursued without it. That distinction sounds technical, but it matters in the real world. If the government were only defending a dead rule, this would mostly be cleanup litigation. But that is not what this filing says. What it says is that the agency still claims room to make case-by-case judgments under the statute itself. So the legal question has narrowed, but it has not disappeared. That is also why I think the most accurate way to frame this update on Thomas Updates is not the brace ban is back, because that would be wrong. The accurate frame is narrower than that, and honestly, more unsettling for people trying to understand the current rule set. The formal brace rule is gone, but the government is preserving the theory that some brace-equipped pistols may still fall under short-barreled rifle restrictions depending on how it interprets the firearm. If you want these filing-by-filing updates without the noise, subscribe to Thomas Updates. This is one of those issues where one paragraph in a court brief changes the entire conversation. Now, this also explains why some of the public warnings you're seeing are being issued now rather than 2 weeks ago. The concern is no longer hypothetical. It is based on the government's own words in an active case. And because there is still no new merits ruling resolving that broader statutory theory once and for all, the uncertainty is doing most of the work here. What the court has actually ruled so far is still limited. In the separate mock litigation, the brace rule itself was vacated, and that remains the posture. The government later dropped its appeal in that case, which is why the 2023 rule is not currently in force. But in this Texas case, the March 16 brief shows DOJ is trying to end the case on mootness grounds while still preserving ATF's position that some brace-equipped pistols can be regulated under the existing statutes. So the current dispute is no longer just about whether the old rule survives. It is about whether the court can still give relief against the legal theory behind it. If you want the full step-by-step on how we got here, go back to my previous Thomas Updates video on the Texas pistol brace case because I already walked through the filing, the procedural posture, and what changed on March 16th. For today's update, the key point is tighter than that. The warning now being raised is tied directly to a position the government has openly taken in court, not just online speculation. So what does this change right now? As of today, it does not create a new rule. It does not change the fact that the old brace rule was vacated. It does not mean every braced pistol is automatically treated as an SBR, and it does not mean there has been a final court decision in the Texas case. What it does mean is that the government has now clearly stated it does not view vacatur of the rule as the end of every possible brace-related enforcement theory. And that brings us to what comes next. As analysis, not prediction, there are really two paths to watch. First, the court could agree with the government that the case is moot and dismiss it, which would likely push this issue into future enforcement cases or more targeted civil challenges. Second, the court could decide there is still meaningful relief to consider, in which case the broader statutory theory stays directly in play in this case. Either way, this is not fully resolved, and that is the real update. So the bottom line tonight is straightforward. The brace rule itself is still gone. The March 16 DOJ filing did not revive it, but the filing did make something else very clear. The federal government still says some brace-equipped pistols may be regulated under existing law even without that rule on the books. That is why the warnings are getting louder, and that is why this case still matters. If there is a ruling on mootness or another filing that changes the posture, I'll have that update next here on Thomas Updates, so if you want the follow-up, subscribe. And as always, I'm pulling this from public court filings, official government materials, and public statements for informational and educational purposes. This reflects my analysis of those public sources, not legal advice, and if a specific legal issue affects you directly, talk to a licensed attorney in your state.